far as staff? Okay, everybody, we're going to go ahead and get started. Call the meeting to order at 7 p.m. right on time. Suzanne, roll call, please.
Thank you. Mayor Labar is absent. Mayor Pro Tem Case,
Here.
Councilmember Alfieri,
Here.
Councilmember Nakai,
Here.
Councilmember Neal,
Here.
Councilmember Zulawaga.
Present.
Thank you very much.
Okay, stand for the Pledge of Allegiance, please. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. America, we love you.
Okay, we're on item 3, ceremonies and presentations. I'd just like to say that the mayor is absent today, and I'm going to do my best to preside this evening. So patience with me, if you would, please. Do we have any ceremonies, presentations, or appointments? Doesn't look like it. Suzanne, any additions, deletions, or corrections to the agenda?
No, ma'am.
Thank you. Okay, the consent calendar, we have one item. Approval of a bulk water fill station equipment and materials for $30,157.97. Kip?
Yes, I brought this to council tonight because it's not in the current budget. We've been looking at this project for quite some time. We've got numerous bids on the equipment. We've looked at numerous locations. In the packet I showed you where we're intending to go with this fill station. And so we currently use a fire hydrant on Walnut, right across from the auto glass broker. It's basically fill on an honor system. And we would like to, I'll say, tighten in on our water usage and make sure we're accounting for it more accurately. The new location is just around the corner at Midland and Highway 67. There is a current building there already. That building consists of 2 rooms. One room was to be used for a chlorine injection system, and it's not being used for that. So, and it's already plumbed, if you will, with the pipe coming up from the system or the distribution system underground. We simply tie into that with this request with the equipment, and then also I'll say modernize the technology to where users can simply put in their account, swipe credit cards, get the proper amount of water and have less spillage. Also with this is a backflow prevention system. So we protect our distribution system from cross connection, because that's probably what takes most of our time with just staff training commercial users on how to fill their apparatuses, if you will, safely. And we're going to better track it. What questions can I answer?
Rusty?
Kip, when I met with the fire chief, he told me that they only have a certain amount of water on their water trucks and the capabilities. Is this one of the stations that they would be refilling their water tanks in a fire situation?
They could. Typically the fire hydrant will hook up, or the fire department will hook up to any fire hydrant. They have one right outside their station that they currently use to fill their trucks. But we don't charge the fire department to fight fires for the water. So they'll fill anywhere.
Does this have a higher capacity or output flow, the new facility that you're proposing?
No, it's pretty close to the same. I mean, it's just based on elevation of our tanks and that head difference. And the current location to the proposed location, I'd say there's maybe a 5-foot difference in elevation between the two. So it'll be same flow rates. The nice thing about the new station is there'll be less waste because they can tell how much water to put into it. And it automatically closes a valve when that volume has been hit. Where now they simply start closing the fire hydrant after their truck is full. and you got a lot of spillage.
Thank you very much. I had seen what you had put for your rationale. I was trying to find out if there were any other good reasons why we would do that. Thank you very much.
Robert?
Thanks, Skip. I asked you earlier about where I see the new pump station, at least the pictures you show us of it there. Looks to me like there's a sidewalk on one side. I'm trying to visualize where the trucks are going to pull up, and is that going to be on a private part of the street? Is it open access? Is it longer extensions needed? Stuff like that.
There's actually two spots that could pull up right on Midland, and that would require a longer hose to get to Midland itself, but easy in, easy off is in regards to the highway. And they could also pull up on that frontage road right there as well, depending on size of truck. So it's ideal for them to pull off of Midland because that's more of a, I'll say a busier street, but not all trucks can make that turn. Currently, the trucks now at the current location just pull up to the side of the road, hook up and start filling. So they'd be doing a similar thing, but they have the option to pull on the frontage road as well.
So will the hoses they need be their responsibility to have to reach to the location?
Yes, sir.
Okay. So do you envision the city is going to have to incur other roadworks in the future to accommodate that location?
We'll see how much wear and tear depending on trucks turning and how sharp they're turning in there, see if it tears up the asphalt to any. Potentially, yes, but not, I don't currently see us doing anything right away.
Okay. And the last question I have has to do with the revenues. So I get it. We've got some spillage going on and some honor system, which is subject to nothing that's measurable. What do you anticipate an increase in revenues by? I mean, I recognize this is not a budget item. So what do you anticipate a recovery of that revenue over X amount of
Yeah,
time?
bulk water sales isn't a large portion of our revenue stream.
Okay.
I'm more interested in accounting for all of our water accurately. So let's say, for example, if water usage goes up in the bulk fill station, that we're more accurately tracking it, I can account for it better and allocate water in the future. Right now, it's just simply chalked up as a loss and it's an honor system. So when someone fills their truck and truck starts spilling, they shut it off. And I don't know how much is spilled and they don't track that either. They just write down how many gallons they filled their truck.
Gotcha.
So, or what their tank size is. So, okay. I would say maybe, if I were to guess, bulk sales might go up 10%, but it's not a big number as it is.
Okay. Just better control.
Yeah.
Thank you.
Council, any other questions? Okay, I will looking for a motion.
I will. So moved. Move to approve the bulk water fill station equipment and materials of $30,157.97 per presentation by Kip Wiley.
I'll second.
Suzanne?
Yes, ma'am. Just 1 second. We will have to do this manually. We don't have one council member not signed in yet, so. Alfieri,
Yes.
Case,
Yes.
Nakai,
Yes.
Neil,
Yes.
Zulawaga.
Yes.
Thank you. Motion carries unanimously.
Thank you, Council.
Thank you, Kip. Do we have any, Rob, do we have anyone signed up on the sign-up sheet for public comment? Thank you. Suzanne?
Nobody on Zoom.
Okay. Anyone in the audience wish to address the council? All right, seeing none. We'll move on to item 7, unfinished business. Item A, approval of the Board of Adjustments Rules of Procedures. And I understand that Lou Ramon is not with us this evening, and so we will be hearing from Karen Schmeek, our planning director. I believe she's on Zoom.
She is. She's available.
Coming. Good evening, everyone. You may recall at the last meeting, Councilmember Neal had very graciously volunteered to sit down with our board chair, Lou Ramon, and Jim Rumsey, and kind of work out a couple of finer details within those rules of procedure. And they had that meeting, and it is definitely a much better product because of their efforts. However, there is still one larger point that we want to make sure everybody is comfortable with. So at this point, we don't consider this ready for council ratification. We want to go back to the Board of Adjustment at their next meeting on February 28th. And just make sure everybody on the board understands where we are with the rules of the procedure and the processes and parameters that we have to stay within under state law. And once we have them fully understanding where we are, we will be back in front of City Council, and we are estimating that that date would be March 17th when we would be back asking for council to ratify the rules of procedure.
Thank you. Council? Yes, Robert, go ahead. I mean, Councilmember Zulu, I guess. Sorry for the informality.
I just want to mention to those who are reviewing this, that before it comes back to council, I'd like you to look at 3.5, the way the public is treated in this. What I see it saying is any persons disrupting the board meeting will be given one verbal warning and then will be asked by the chairman to cease the disruptive behavior. In the event of any disturbance or disorderly conduct, the chairman will have the power to order any individual or group individuals to be cleared or removed from the meeting, and will have authority to appoint a member of the police department as a temporary sergeant at arms for the purposes of preserving order in the physical meeting room. I have a bit of a problem with that. And the fact that the chairman may limit the amount of time an individual may speak to 5 minutes and limit the total time of public comment. And yet, in the next section, 3.6, it says the chairman may limit the scheduled time allocated for variant applicants, appellants, and the city presenters to 20 minutes each. So the presenter has 4 times the amount of time as a community member does to make their case. And I just wonder, especially in something that goes before the Board of Adjustments, that we should give the Board of Adjustments such control in muzzling the voice of those who are appealing. So I'd like to see that looked at.
Rusty? I mean, Councilmember Neal.
Yes, I'm going to second that request. That was something that I did discuss with Louis. I think by hearing it from 2 council members, it may carry more weight than just myself bringing up some of the time limits that are going to be coming forward to us. I would ask that they also look at that paragraph with Robert. The piece of information I wanted to provide to the city council and to all the citizens is I'm glad we did have a very brief conversation about this last week, because when I said I would be meeting with Louis, I did get a telephone call from a citizen who happened to be on the Board of Adjustment. Technically, it's Board of Adjustment number 1. The one that I pleaded was Board of Adjustment number 2, even though the sequence we went first. Ours was number 2, theirs was number 1. He actually provided some feedback to me that I took to the meeting that I had with Mr. Ramon, and was very pleased to report back to the citizen that 2 of those items had already been incorporated. So they saw some of the problems that they were seeing. One of them was the appearance of the impartiality of having a member of the defense being able to be the secretary. It just did not show as being impartial. So one of the changes that we discussed, and they will be taking back to the BOA members, is that whoever the secretary is designated to take the notes, it cannot come from the defense or either side of the case. It can't come from the plaintiff or the defendant sitting up here at the dais. It just gives a very bad appearance of non-impartiality. So that was being corrected, and I was happy to report back to the citizen. The second one was the appeal process to the district court, making it clear. It's crystal clear in the new language. I thought it was fairly clear in the beginning, but it's even stronger. The third thing that he brought up, and this is probably one of the key things that are going to be going back to the BOA to discuss, there is a 30-minute clock that starts after a BOA case for the plaintiff to appeal the decision of the BOA. At the time that these cases were adjudicated, both the case I was involved with and this case, it wasn't clear when the clock started. That 30 days was exceeded by, I believe it was 2 days at district court level. So that case was never heard because it was a technicality. It was 32 days when they filed their petition. The judge was very clear in the ruling at district court. He established precedents. The clock starts at the verbal decision of the BOA. So that does. That case was thinking it started when they received the written findings of the BOA signed by the secretary. So it's clear now we have a precedence. What starts the clock, it is 30 calendar days. But the point that was asked to be looked at is the city has 15 of those calendar days out of the 30. And then the plaintiff only has 30 days to take 15 days to get the written document, which anybody who's worked with a law firm or a lawyer, they need to see what they're going to be building a case around in writing. They can't go by verbal, exchanges. They can get preliminary discussions, but they want to see the language so they have something to really write up their case. If half of the time is gone before they're even given the document to start building their case, it didn't seem fair. So they're going to take a look at the time. Now, the city did point out that they need a certain amount of time. Nina and Jeff and Elliot need a certain amount of time, our law firm, so that the city puts together a good document so that we're not at risk either. So they're going to take a look at somewhere between a 5 and 15 day time for the written finding to be given. That's one of the big things they're going to take back to the BOA for adjustment. And that's why I think the motion is going to be coming up to a motion to table this one more meeting, but I'll wait to see what the further conversation goes.
I think from what I took away from the presentation by staff, they're asking this to be tabled to March 17th meeting. So whomever makes the motion, just remember that that's the date they're looking for. Anyone else?
And Nina, did I kind of represent it well, accurate?
Yeah, and I just want to say, I just met with Lou on it, and I'll be there, Lou Ramon, the chairman of the Board of Adjustment, and I'll be there on February 28th to answer any legal questions. I think it's best if anyone has any issues to go to that meeting, because the Board of Adjustment, they're your volunteer appointed board. They work hard, and they've been like in the trenches. So making the proposed amendments at that meeting, if you can, versus kind of talking that through. I think the meeting will just be discussing that. So that's on February 28th at 6:30 here.
I would strongly agree to, if we could get citizen participation at that meeting,
Yes.
because they're the ones really wrestle it through and make the recommendation to us, so that we are really just that oversight of their recommendation. But we may have some further discussions based on what you brought up, Robert.
26 or 28?
28th, Monday, February 28th at 6:30.
Anyone else, Council? Yes, Ms. Alfieri.
So I would like to point out one other section that is really a hang up for me. 3.6 presenter discussion. And for those of them that don't have this in front of them, it reads, the chairman may limit the scheduled time allocated for variance applicants, appellates, and or city presentations to 20 minutes each. If the chairman chooses to establish these time limits for presenter discussion, they will be included in the posted meeting agenda, and she must also inform all presenters at the start of the hearing. It's my belief that when a citizen comes before the Board of Adjustments to request a variance or to appeal a decision, to limit their time, especially to 20 minutes, I think it's doing them injustice. I think they have not only the right, but should have the leniency to be able to plead their case in whatever way, in whatever form, and as long as they need to do it. That might seem extreme to some. I don't think most would like to sit up here for 3 hours and plead their case, but 20 minutes seems excessively short. And I am very concerned about limiting such a presentation when, again, the citizens are coming to a board of the city to potentially rectify what they think is a wrong decision. So that is a serious concern for me, and I would like to see it extended quite a bit, if not removed entirely.
So the way I read this, this is not for an appeal, but just for a variance.
No, it's both.
Well, it does say appellates.
Okay, all right. As far as the variance goes, I sat up there for 2 years. We had nothing that ever took more than 10 minutes. On the appeal, I don't have a problem not setting a limit. So maybe you separate it out, but a variance doesn't take that long generally. And I don't ever remember, to be honest, setting a clock on a variance application anyway. So it's not, I think this is really more of a, if you get into one of the appeals like we had where it was a 5.5 hour appeal, and it was just people getting up there reiterating the same, which I didn't disagree with. Trust me, I didn't disagree with the appeal, the comments, but at some point you have to stop having people say the same thing over and over again. So I don't know the answer. So
Yeah.
that's why we need to address it.
I
So
can appreciate that it may not necessarily always be necessary, but I do disagree with limiting citizen participation in any way.
it
to
says,
any length of time.
it does say may and not shall.
Agreed.
So
And I'd like that protected for the citizens.
like I said, we can have the discussion. I'm just telling you my experience on the board.
Councilmember Neal, go ahead.
Yeah, I just wanted to make sure before I spoke again that everybody had a first chance. Stephanie, I strongly agree with you, and I'm glad you brought it up. I brought it up to Mr. Ramon. Robert has voiced it around paragraph 3.5, but paragraph 3.6 is also the same. I felt I was being a little biased because when I was objecting to the 20-minute limit, it was because I found out that I would only have 20 minutes when I came to the microphone to present my case. I had a script, I had timed it. It was going to take 30 minutes to read the script. So on the fly, I'm not a trial lawyer, so adjusting how much time I had, it seemed unfair. Perhaps some limit would be reasonable, but the 20 minutes to get out a legal case is damn near impossible. Anybody that ever tries to appeal anything and you put together a legal defense, you first have to establish an error, and and it takes a while to establish an error, then you can go into what you're wanting to do. It takes more than 20 minutes when you're talking about an appeal of somebody's property rights. So the 20 minutes, I think, is far too short, but perhaps some reasonable amount. We don't want the poor Board of Adjustment, because they're all volunteers, to be there all night. And we're paying for legal counsel to be sitting there while the clock is ticking. It's costing the citizens money. So we have to balance it out. I agree with you, Catherine, but I also, 20 is way too short.
So when we discussed this, if, as I recall, that was one of the reasons we put in here that it would be posted on the agenda beforehand, so that you would have known you get 20 minutes, or this time you get 45 minutes, or this time you get an hour. That was one of the reasons we put it would be posted, as opposed to it not necessarily being set at 20 minutes. It could be posted 30 minutes or 45. That was the intent that I remember at any rate. So
I think those are good guidance to send back to the BOA to discuss and maybe scratch their head, but hearing it come from 3 council members that maybe 24 also, when you think about how you're presenting it, Catherine, hopefully they will take it to heart and come up with a little bit better solution.
Well, I would just say that I think I agree with you all. I think limiting, because there'll be things that are shorter and there'll be things that are quite a bit longer for time to present. You know, we've experienced some things in the past with some passionate issues where we had an audience full of folks, and I think maybe you guys have even experienced it. And what they did to manage what you were concerned about, Catherine, is people repeating the same thing over and over again, is to ask the audience if they have any new information to bring that hasn't already been presented. To ask folks to think about that is a tool that you can use to try and manage the redundancy and manage time for the volunteers that are there. So just as a suggestion, but I would agree. Anything else, council?
I
you'd
would
like to
just
share?
make one comment. I know that's common practice among council, board of adjustments and such. But I feel it's necessary to make the comment that just because you might have 5 citizens that come up and say the exact same thing, that doesn't negate what they're saying. That tells you there's a large portion of people who all feel the same way. That's always been a practice that I've never agreed with, limiting public comment just because people are saying the same thing. I want to hear how many people see it the same way and feel the same way on an issue.
And I don't think that the council's ever asked them not to speak. I think they just,
Oh, yes.
okay.
Oh, yes. No,
Well,
I've,
it's not in my memory. Sorry, I don't
Right.
remember it, but
so
I
Councilmember
would never
Alfieri,
discourage
I
that.
totally agree with what you're saying. Yeah, it's like
Just
if
an
there's a dozen people who want to say the same thing, it's because there's a dozen people who have a concern about the same thing. And just to say, okay, I heard it once, shut up, the rest of you, I think is not the right approach.
I don't think anyone would say that, but it was just a thought.
You are
Thank you.
saying that by saying you can't speak.
Anything else, council? All right, looking for a motion to table this to March 17th, 2022.
I'll
Council.
make a motion to table item 7 alpha, the approval of the Board of Adjustment Rules of Procedures to our next
March-
council.
March
meeting.
March
17th.
To the March
Two council
7,
meetings.
I'm sorry, to 2 council meetings from this point in time.
Thank
Oh.
you.
I'll second.
Thank you. Any further discussion?
Councilmember-
Anyone in the public would like to say anything? I'm sorry I didn't offer. Thank you. Suzanne?
Council, you may vote.
Sure.
Thank you, Karen.
Thank you, council. Motion's carried unanimously.
Thank you. All right, moving on to item 8, ordinances on initial posting. Item A is to consider ordinance 1418, series 2022 on initial posting. Again, this is initial posting, council. I'll share with you. And it wasn't marked, but I'll share with you all as well that this is a legislative item. And so it's from this amending chapter 1.16 of the Woodland Parks Municipal Code. We will have the Judge McClintock this evening give us a presentation. Welcome.
Good evening. I'm here this evening to speak about this amended ordinance. This comes about because the state legislature in a House bill, as indicated in the preamble to this amended ordinance, saw fit to get rid of a mechanism that the courts have used for decades now. When people didn't pay their fines or any of their court fees, things like that, we could use what's called an OJW, an outstanding judgment on a warrant fee. That would get transmitted to the Department of Revenue. And it was basically a $30 fee that would get noted. And then when someone would go and try to renew their driver's license, they would run into a problem. They couldn't renew their driver's license until they had cleared this problem in a court. And this was true across all courts, county courts, district courts, municipal courts, all courts in the state. And this had been in place for, like I said, decades. It was a standard practice. When I was a baby DA, I would have people come into traffic court and they wouldn't understand why their license was suspended. And I would be like, well, let's look at your driving record. And I could tell very clearly they would have an OJW there. And I'd say you'd need to go and figure out where this ticket is, take care of it. You can go to DMV then, get your license and we can get some things straightened out. This last legislative session, the legislature really focused in on taking that power away from municipal courts. It affected county courts to some extent, but it really hit municipal courts very hard because it took away not just on traffic tickets, but on all municipal court violations. So we have no mechanism for enforcing when our fines and fees are not paid anymore. So that is why we needed to have some sort of mechanism to try to enforce collection on some of our fines and fees that people were not paying. And believe it or not, our ordinance didn't have anything in particular to do that. So we were looking into that, and that's why we had this proposed ordinance. And this is something that not just our court is looking at, but really every municipal court in the state is having to address this. And this is something that is addressed pretty much every day on the judges listserv that I'm on. It comes up every day. We're still trying to deal with past OJWs that are in the system, what we need to do to clear those. It's just a real problem, a headache. There's memos constantly coming out from the Department of Revenue and how they're going to be addressing it. It's a very fluid situation still. But Carla, our court clerk, has been very proactive in trying to deal with ours that are in the system. And we're trying to be proactive and having you look at this ordinance and see if you'll approve it and go forward with this. We have about $5,000 in outstanding fines and fees that need to be collected. Carla is very good at getting people who are more recent and getting things paid. She follows up with people all the time on the phone. We don't try to collect extra fees or anything like that. You know, we work with people very often to try to get things paid. We work with payment plans. We do all of that. We don't try to make anything terrible on people to get fines or anything like that. But it's also not fair to the people who do come to court and who do take care of their fines, that the other people who just don't pay get to let these things slide. So that's why we're trying to get this mechanism in place. You know, I thought the old system that was in place worked really efficiently. It worked really well, but we need something else now. So that's why this is here.
Thank you. Council, this is first reading and setting the public hearing for February 17th. Anything else? Mr. Councilmember Zulog.
Yes, Judge McClintock, I'd like to just ask a couple of questions
Sure.
about kind of the background on this.
Yes.
So prior to the state changing the whole ability for you to collect through the Department of Revenue, when you did you get like full, like say you had 5,000 last year, year before, whatever, did you get all that collected, cycling through when people realized they couldn't renew their license?
Generally, yes. People would, when it would come up, you know, it's a constant rotation. And, you know, when your
Sure.
license would come up for renewal, then the people would contact the court and they would pay their fine to us. They'd pay the extra $30 and then they'd be able to get that cleared from us. We would send in, Carla, would send in the clearance to the Department of Revenue, and then they could go and get their license. Right now, what they can do is they can just pay the state $95 and get their license renewed. So the state can collect $95 and they don't have to pay the court the fine and clear what they owe the court. So it's very, yeah, that's the same thing. And that's what, when we go to judges conference and we all sit here and we read that, we're like, oh, I see. So it was fine for the state to collect $95 so that they can get their licenses back, but not to address the actual consequence of the bad driving behavior. But that's how they decided to address it, yes.
Without being cynical, are you suggesting that the state is able to add a new revenue source?
Well,
Is that
that's what happened.
Yeah.
And, you know,
at your expense? So doesn't matter the fact they owe us $150 or whatever it might be.
right.
Yeah, okay.
There's been a lot of discussion in the last couple of years how there has been a concerted effort to take away a lot of, I wouldn't say power, but a lot of the mechanisms that municipal courts have been able to use in order to function. And that is because there are groups that really want to get rid of municipal courts altogether. And so, we really don't have the power to arrest people for a lot of our violations anymore.
We saw this last council meeting, this exact thing.
Yes. And so it's, the ACLU has had a lot to do with that. It's a very, more liberal, I would say, legislature currently. And so, the pendulum swings every time and things will swing back the other way too. But right now, this is where we're at.
Thank you. So my last question then is, so if this goes to debt collection,
Right.
is there some statistic on how effective that is?
We have no statistics on that yet. I imagine, and there'll be an upswing in an industry of debt collection. I'm sure that eventually there will be one or two debt collectors that will emerge as the preeminent people that work with smaller jurisdictions, and they will have all the business for the small jurisdictions, and they will do the best job, and they will have all the business. And
With
how
some
it
debt collection, you cannot discharge it with a bankruptcy. Is that true with these court fines? Are they dischargeable in bankruptcy, or do they retain?
I am not certain on that.
Okay.
But I know that some, if they are doing any collection for restitution, that should not be dischargeable in bankruptcy, because that would be similar to the state restitution statutes. However, fines and court costs, I would imagine, but I'm not positive. I'm not positive on that. And that's where a debt collection agency is going to have to be knowledgeable in debt collection practices. We do have one person that owes approximately $2,000 in restitution to a victim of an assault. And that one, we're just not giving up on. That one will never go away, and we're going to keep, going after that, because that was for hospital bills for a person. And, those are things that, we will not allow to go away.
So council, this is first reading again. I don't mean to stop, but
Sorry.
but we should have this conversation in the public hearing when it's advertised for February 17th. Rusty?
Yeah, in fact, I was just going to say, since this is simply the initial posting, my question is, Judge McClintock, will you be available on February 17th to come back? Because this is, if we do vote to move it forward, I probably will. If the public were to attend it in any, well, even if one person came and asked a harder question than we could possibly come up with, I wanted to make sure you were going to be available for that.
Yes, I was planning on being here the 17th.
Thank you.
Thank you. Council, I'll look for a motion.
I motion to move the ordinance number 1418 series 2022 on initial posting as an ordinance of the City Council for the City of Woodland Park, Colorado, amending Chapter 1.6 of the Woodland Park Municipal Code to establish a procedure for the collection of unpaid municipal court fines and set the public hearing for February 17th, 2022.
I'll second.
1.16. I apologize.
Thank you, council. Any other comments? Any public comment at all?
Yeah, I second it. I'll second it. Unless
Councilmember
Stephanie-
Vogt?
Thank you. Okay, moving on. Oh, I'm sorry, Suzanne.
Sorry. My thing went to sleep.
Thank you. Motion's carried unanimously.
Thank you. Okay, council, move on to item 9, public hearings. Item A is approval of ordinance number 1417, series 2022, and ordinance amending multiple titles of the Woodland Park Municipal Code regarding code penalties and violations. Again, this is a legislative item, and I will turn this over to Nina Williams, our city attorney.
Yes, thank you, Mayor Pro Tem and Council. I will explain this ordinance. It's a comprehensive review that we took of the municipal code due to a new state legislation over the past few years. And an additional item that they've placed on municipalities is that cities need to pay indigent defendants where in prison is a possible penalty. So I've done these cleanups ordinances for a lot of our other cities, and it looks through the code and sees where is that actually a potential that you're actually going to use imprisonment. Otherwise, you should remove it from the code as a possible penalty because basically just conserve taxpayer resources. Otherwise, you need to pay for an attorney to represent somebody who claims that they're indigent. So we looked through that, and then we also updated the maximum fine from $1,000 to the $2,650 because that was also allowed pursuant to a new state, not new, that was actually about 8 years ago, a state bill. So any questions?
Council members Zuluaga.
I have a question. Seeing we have the judge with us here, I would like your input on this proposed change. And if you've reviewed these and agree that we're not dropping the ball with some of the fair justice that's required to protect the community versus the expediency of saving a dollar.
Well, I mean, I agree. We have to go along with the state statutes anymore. And honestly, in the 5 years that I have been on the bench here, we've only had one defendant who I've come in contact with that I even thought warranted a jail sentence. And in her case, because of she had mental health issues. I would say the only thing I thought was appropriate for her with her mental situation was a home detention type of sentence. And most of the time when we appoint counsel for defendants, it has more to do with 1, they're juveniles, or 2, there's a mental health issue involved as well. And that's just because it makes it easier for them to understand the process. And we have a concern that their rights would be violated because they don't understand the process. And we see that more and more right now. We have a lot of people coming in contact with the court that have mental health issues of late. We have an increase in a transient population that is coming in. And I'm sure everybody sees that around town. But in regards to sending people to jail, our police department is very good at, if the crime is so serious that is somebody that would need a jail sentence, typically they're getting charged into county court anyway. And so they don't come to municipal court typically.
Okay.
Yeah. So I think cleaning up our ordinances in this way is effective, and changing our maximum fine. It's good so that we're in accordance with the state statutes and how it should be. I can tell you, if you've ever sat through one of my advisements in the morning, it'll make it clearer for people coming in on initial advisement, because I go through 3 separate possible fines This will make it just even and one possible fine that can be imposed, because I can tell people get confused. And I have to call them up individually and tell them which fine would be applicable in their case. And this will just make it cleaner for them. They won't be as confused. I've never once imposed the maximum fine that's been available, because typically, again, it's not warranted. We typically don't have a situation most of the time of the charges that we get in municipal court. I would imagine if I had somebody who was a repeat offender, that it might be imposed, but again, people who are repeat offenders don't get brought into muni court. So, sorry.
Judge McClintock,
Yep.
stand fast.
Sure.
It's fortuitous that you're
Yep.
here.
Yes, Councilmember.
Okay. I would like you to hear my comment, and if it turns into a question, I would like your thoughts on it. When we had the initial reading, Stephanie Alfieri did bring up an argument about, we're kind of raising the level of the penalty on a lot of things that maybe we should be looking at some of them and not having quite the level, jumping up to 25 or 26.50.
The maximum amount.
And the one that came to mind immediately, which is why I liked what she said, was the wildlife fine. So I went into the wildlife, the feeding of the wildlife penalty. And what bothers me about the current language is if somebody is found found to be violating that part of the code and is a fine is assessed, it has a mandatory minimum of $350 on the first violation. And then the second, it shall be a fine of, now this one, it's not less than four. So again, it drives it to a certain level, which means you don't have any say if there's extenuating or mitigating circumstances where you want to slap their hand but don't want to hit them with a $350 fine. So I laud what you were saying by having such a high level, but the language actually says it's now your judgment, whether it's zero up to that to include feeding the. Do you like having guidance that says it's a minimum fine, you don't have a say in it, or would you like the flexibility to weigh extenuation and mitigation in your decision?
Well, so I know on the wildlife feeding one, the reason why they put that in there is because I know that when they come, they get that ticket, they've already had a certain number of warnings already. Because when they put that in there, there was an agreement that they wouldn't get that, they wouldn't be in municipal court until they had already had a certain number of warnings. I think they had to have, I thought, 3 warnings before they would get a ticket in the first place. And that was the agreement. And so that's why I knew they put that fine in there like that. I always prefer to have discretion in giving out fines, but I understood why they did that. And that was because we have such a problem with people feeding the wildlife. And they wanted to make the point because they did have people literally just sticking checks on trees and saying, they were telling me that. They were coming into court going, she just stuck a check on the tree to pay me. And that's what, that's what I heard. And I was like, okay, I understand. And so when you hear that, you kind of like, wow. But, in regards to that, the $2,650, when you think about it, that is the maximum possible penalty for a traffic infraction. And so it sounds very strange when I give the advisement in court, when I tell people on their traffic tickets that that's the maximum possible penalty I can give them for their speeding ticket, but it's not the maximum possible penalty I can give them for an ordinance violation in the city. So if you harass your neighbor, you can get a lower fine than if you speed in town.
Stephanie, thoughts on my,
I do. Yeah, you kind of touched on where I was going. I don't know. Does anybody have any other questions for Judge McClintock or?
Your go.
Okay, I didn't have any other questions. So I was gonna see if she was like, get me out of the spotlight.
No, I'm just-
I was not
I'm like, if I'm
expecting
here,
this.
I mean, because I would love for you guys to come to court sometimes.
Yeah.
Because I always invite you guys to come.
well,
I try and
you kinda
avoid
left
court
me-
as much as possible.
I know.
You left me hanging though with your comment about you can harass your neighbor and get less of a fine than speeding. So are you saying that it's worth harassing your neighbor?
No, I'm not encouraging that at all. It just seems so inconsistent to me sometimes that it's just, and when I give the advisement out, people are always sitting there and they seem so dumbfounded when I tell them the maximum possible penalty I can give you for a speeding ticket is $2,650. And then I go through the maximum possible penalty you can get for a traffic misdemeanor, which includes careless driving, reckless driving, engaging in a speeding contest, is a fine of up to $2,650 and or up to a year in jail. And then I say, if you violated an ordinance of the city of Woodland Park, such as harassment or any of our other ordinances, the maximum possible penalty you could get is a fine of up to $1,000 and or up to a year in jail. And so, careless driving in town could get you up to a year in jail and a fine of up to $2,650. But
so in your opinion,
so-
the increase to kind of even it makes sense to you as a judge?
yeah, it makes consistency across, and just having it just makes more sense.
Thank you.
And one final question. So the person who posts a check on the tree,
Yeah,
would they then post $1,000 check? And then next, would they put handcuffs up there or?
I have not done that yet. They've not with the other, but that's because they have to get cited into court and come in and explain themselves at that point in time. And usually by then they feel a little bit chastened, so they stop, but I haven't actually had any of those since, we've only had one person since that ordinance went into effect.
Nice.
And so it must be having an
Having its
impact.
turn,
People
yeah.
understand it now, so. And so I think that's good. Thank you.
Thank you.
Nina, do you have anything?
Thanks very
else
much.
you'd like
That's
to
great.
add? Not unless the council has any questions. We just, like I said, made sure everything's consistent in the code. We highly recommend it. And if you have any questions, you could ask me before or after your public comment.
Yeah, I still have comments to make. I just didn't want to make Judge McClintock stand up there forever. So yes, Councilmember Neal, you touched on a number of the concerns that I have with this. And I think Judge McClintock highlighted it. The idea that we have fines set for our citizens that are the same for, again, careless driving, or it, before Judge McClintock spoke, the ones that I had pulled out was the sale or possession of marijuana. That has the same penalty, maximum penalty for it, just in the municipal level as, again, feeding the deer. This is uncomfortable for me. Those are drastically different offenses, and to set the same maximum penalty for them, I can't see where that's justifiable. I will say this, and of course, this is not directed to Judge McClintock at all. I think you do a great job of using discretion to set these penalties, but that may not always be the case. And part of our job is to limit what's being imposed on our citizens. We can't always trust to have a judge that might use such discretion as Judge McClintock does. So limiting those based on the infraction just seems to be the reasonable thing to do. As well as Councilmember Neal, you already touched on the fact some of these are set at a maximum of $100 or $300, and all of the sudden we're jumping those up thousands of percent. I'm not comfortable with it. I think it's a very simple, clean and easy way to make this cohesive and to make it streamlined, but I don't think it's in the best interest of the citizens to do it that way. Unfortunately, it would be much more cumbersome to go through and set the penalties according to the violation. But that's how we have always done it. I just simply can't get on board with some of these infractions of the municipal code, having a charge up to, $2,650, which is, again, the same that we might charge for some sort of, again, like Judge McClintock said, whether it be careless driving, some sort of harassment. It just doesn't seem to make sense to me that we would set the fees for all municipal code infractions at the same level, regardless of what that violation is. So that's my concern, and I simply can't support this the way it's written.
So Nina, given those comments, do you see another way of resolving this in a more, I know you're trying to do it in a streamlined way, but in a more balanced way that's reflective of, in other words, I'm going to go back one step and say, it sounds to me like we are once again reacting to state legislators changing the rules of the game. So that means that we are losing municipal control yet again. And now we're trying to find some way to make it efficient. But I think Councilmember Alfieri's got an excellent point. So how do we maintain control given the fact we're losing control?
Yeah, you keep control with, each offense or each situation is different. And I'm sure that this $300, for example, section might have been, 10, 20 years ago. A lot of my cities, it's like there's this egregious case and it's like there's no other way, because the state legislature has been taking away the right to even put a lot of people in jail and that sort of thing is for fines. So there's a certain situation where you wish you had that, this gives more control to the cities to have that maximum fine. That being said, that's not, that was just to, I put that in as I did with all my other cities to give more control to the city in those certain egregious circumstances, and also to be consistent with the model traffic code. That being said, it's not, it's more important to take away the imprisonment where it doesn't make sense for some of these violations than to change, the fee. We were just trying to make that consistent, but there are a lot of other changes we made in this ordinance that we highly recommend that are important than the decision for the amount of fines, which just going through, I could see different things that we're striking for imprisonment conviction, because like the judge said, the person's never going to be convicted for that. So not to pay for the indigent defense. So I hope that answered your question.
Well, in part, yeah. So would it be, to me, a way that we could solve this is by having a schedule on this, which lists the different issues and the fines, and create a schedule on here.
Yes.
And then that schedule periodically, if the court found it necessary for the fines to be changed, that schedule could be changed instead of, so the ordinance is in place with a schedule, and anything that would change would perhaps.
Yes, and that's what a
be
lot
the
of my
schedule.
cities do. It's still the maximum is the maximum, but then I don't know if you guys have that in your fines, your fee schedule, but a lot of my cities in their fee schedule, they have exactly what you're saying, because the community has said, dog bites are, more egregious to us than if somebody is, I don't know, has their dog without a leash. It's very community based. The ordinance refers to can refer to the fine schedule versus in the code, because you're going to look at your fee schedule and your fine schedule more often. And that gives the local control more, because you could amend that every year or as time goes on, instead of an ordinance with the 2 readings and yada yada. So I recommend either way, no matter what your maximum fine is to have that fine schedule to give more control to your community, and saying what you're saying is more egregious than others, and some of my communities have, if someone under 18 is, smoking, they go to a certain program about the dangers of smoking, and they don't want a high fine, it's like, it's whatever the community wants in that fine schedule, but the maximum is still whatever you want the maximum to be. As I'm looking through, most offenses, the maximum was 1,000, other than a few, which were a few hundred. So that's up to you all. You can do both. You can have maximum whatever it is, and then also have that fine schedule. But again, the other amendments that we made in this ordinance are, we highly recommend.
So, Mayor Pro Tem, may I?
Go ahead.
So the way I read this, then you have two things you're trying to accomplish, correct? Raise the
Yes.
fees and remove the
Yeah,
jail
we
time.
combine both those
So
purposes.
what if we just remove the jail time and strike the court fee raising in this ordinance?
Anything that changes if I hear you right, anything that changes the maximum fine,
Or you just leave the maximum fine the way it currently is for whatever the
which is
offenses
still
are.
inconsistent to the judge.
It is inconsistent. I realize that, Judge, sorry. But based on what everybody else is saying, I think getting rid of the imprisonment possibility penalty is more important than the fine. So we could always bring the fine back
Mhm.
with a fee schedule type idea. If that would make everybody.
Yeah, and that should be
you know,
directed by you all. You give policy direction. I'm not going to guess
Right,
in that
right.
case what's important to your community.
Right, but if we
So,
wanted to approve this tonight, we could just do that with removing the fees portion.
And may I clarify, because the fees are increased so that if there is a chance at imprisonment, if we had to cover the cost of the attorney, then we could collect more for that, correct? Did I say that
No,
right at all?
No,
Did that
because they're
make
indigent.
Any sense?
No, because you only pay for the defense counsel if they're indigent, which means they have no money. And it's for most of these things in the code, they would never be sent to jail. So it doesn't make sense. It's
Yeah.
outdated. It's wasting taxpayer money.
And what I was saying to Councilmember Nakai's point is, as the judge stated, we've only had one of those cases in the last year. So I think removing the prison time for now without increasing the fees, if 5 years, I'm sorry, what did I say?
1.
Oh, 5. Yeah. Whereas we can revisit this later if all of the sudden we see an increase of this where we're having to put out a lot of money to pay for defense in the municipal court. We can always revisit this later and look at how we cover the cost of that going forward. But right now, I don't think that there's probably a precedent for us needing to do that, given there's only been one instance.
Can I just
in the
clarify what
last
I
5
think the
years.
judge said, and she could clarify? I think she said there was only one instance where she even thought the penalty should be prison, but there are hundreds of offenses in the code now that a potential is prison, where the judge is saying it's not realistic that they would ever be sent. So you might as well strike that language. And I didn't take away everywhere. I just took away the non-egregious ones. So just to clarify.
So I'd like to just, so I can clarify that my understanding is correct. So we're not increasing the fees. We're increasing the maximum penalty that would be available to the judge to impose upon someone that with a charge from our municipal code. Is that correct? It's a maximum, correct? Nina?
Yes, maximum, yes.
Okay, and the other thing, well, and we all understand that the jail time thing, I think we all agree that that needs to go, and that's part of this ordinance. But the other thing is that she was giving examples of traffic fines versus other kinds of offenses, assault being one of them. Traffic fines are set by the model traffic code in the state. We don't set those fines, as is municipality. And so the inconsistency she described, from what I understood, was that if a speeding fine from the state is at a level, and this may be, excessive, but just for example, $2,650, the maximum, but our code right now says that the maximum for assault is $1,000. That's inconsistent and doesn't make sense. And so that's I think part of the reason why they would like the maximum to be raised to a consistent level. She still has the authority to set the fine as she sees fit to fit the crime. And so I think, am I off base here? Does that help? Because that's what I'm.
And you also could do the fine, like most of my cities that have the fine schedule, they still have the maximum. Again, that's up to you guys what you want to do,
Yeah.
but you could have the maximum be whatever it is, and then also have a fine schedule that says first offense, second offense, third offense for these type of things.
Certainly.
Yeah.
And Councilmember Case, I agree that it's inconsistent, but I don't think the inconsistency warrants increasing the maximum possible penalty for feeding deer to $2,650. So that's my problem with it. Yes, it's inconsistent. Would it take additional time and effort to go through and adjust these if we wanted to? Yes, but I think that's what we owe it to the citizens to do to make it reasonable and rational, since it is consistent right now. I don't think, again, taking the easy way out to be able to just increase the maximum to, say $2,700. I'm just going to say $2,700. It's easy enough. $2,700 for some of these very minor offenses. Again, that's trusting in discretion of our current judge and judges in the future. I have absolutely zero concern about our current judge, but we don't know what we get in the future. It's my experience, eventually, if you give government an inch, they will take the whole mile. So that is my concern here. I cannot support increasing this maximum fine in all the areas of the municipal code, just for the sake of making it easy, because it's inconsistent right now.
Well, I don't think we're taking the short route, but I understand what you're saying. Absolutely. I just was trying to get clarity on what the conversation is really about. So, Councilmember Neal.
And to telegraph my upcoming vote, I really do want to give the municipal judge the flexibility to use your judgment. In the military, if you're an officer, at some point in your career, you are at least going to command once, minimum. I've commanded 3 times. So that means in the military, as a commander, you become a judge. At certain levels, it's a judge with non-judicial punishment, but at certain command levels, you are a federal judge. Summary court martial carries a federal conviction. So the one thing that I always appreciated when I sat as a judge and actually had my own courtrooms was the knowledge that I had a maximum to work with and my judgment on where on the scale to set the punishment. I hear you. We have a good judge. In the future, we may have a bad judge. We hire and fire, so we better hire a good one every time. And we don't like inconsistent rulings, we can get rid of them. But I fully support giving you the flexibility. You have a maximum. If we go back and come up with a table of recommended guidance, I mean, there are guidance on what is the appropriate sentence in all courts. I would like to see, I don't like the mandatory minimums and set things because it takes away the judges and a jury, if there happens to be a jury trial, the ability to take in extenuating and mitigating circumstances and weigh what inappropriate. We just had that state case,
I was
110 year
thinking about that, yeah. The truck driver.
mandatory
Yeah.
sentence, and that was finally commuted down to 10 years. But that came from mandatory guidance. I like discretion that a judge has so that you can use your judgment. If you screw up, we'll know about it, and that's our power to replace the judge. So I guess I've telegraphed where we're going. I love the removal of the jail time. I love the consistency, and that's where I'm at. But I do, let her decide whether it's a $300 fine versus a $10 fine, whatever.
Anything else,
Or
council?
26. Yeah.
Nina?
No, I'm done.
No. Public comment.
Okay. Any public comment? We'll open the public hearing. Anything on Zoom, Suzanne?
No, I have a citizen that made a comment and I'm telling them if they'd like to, they need to say it out loud, not just type it to me. So I'm waiting to see if they raise their hand.
Okay.
I haven't seen it raised.
If she
yet.
does, if they do, would you just let us know and we'll
Yes.
continue our conversation?
Absolutely.
Thank you.
Did she make a comment that we want to know what it said or?
She's just commenting on whatever. I'll tell you what she said, but this is not really the procedure we follow. She needs to raise her hand to say, you just don't put stuff in the chat.
Oh, I see.
But what she's saying is it seems there should be categories of infractions with reasonable algorithms to follow. So I'm just asking her to say that, raise her hand, make
I'll
the
say so.
comment.
The schedule.
Right.
City attorney.
Well, no, I just wanted to say you could do it now or another time to direct, if this is adopted, direct staff to adopt a fine schedule or to present a fine schedule for you all to see. Like I said, I see in my other municipalities, so it could be targeted to your community.
So we can make a motion to approve this with an additional.
For future direction for
future
staff, but
direction
give
for
us a few
staff,
months.
yeah, To
To
create the fee
to
schedule.
present something to you guys. It's up to you to be community specific.
Council, anything else? I'll be looking for a motion.
I'll make a motion to approve ordinance number 1417, series 2022, an ordinance of the city council for the city of Woodland Park, Colorado, amending municipal titles of the Woodland Park Municipal Code regarding code penalties and violations, and to task the city attorney to generate a recommended series of fines
To be
Schedule.
considered for a
Schedule, a fine
potential fine
schedule.
schedule adopted by you, but to be
that
considered by
we
you
would
guys.
adopt, consider and adopt at a later time,
Attorney and staff.
Attorney and staff.
attorney and staff.
Do I have a second?
I'll second.
Okay. Any further discussion, council? Did we have any further public hearing? Did she raise her hand?
No, ma'am.
Okay,
Could I-
thank you. Audience,
Could I suggest a friendly amendment to be such that says that we table this until such time as a schedule is appended to this so that we have a complete package to work with, because to pass something pending something else still leaves us in a space where we are in a place where we're doing something that we're not comfortable with. And I would much prefer to have this as a package. So would you be open to a friendly amendment to change your motion so that we get this all at once?
Yeah, I didn't like combining them together. I would like to amend my motion. I'm
ahead.
going to separate the two actions. I'm going to make a motion to approve ordinance number 1417, series 2022, an ordinance of the city council for the city of Woodland Park, Colorado, amending municipal titles of the Woodland Park Municipal Code regarding code penalties and violations as presented, period.
have a second?
I'll second.
Thank you. Any further discussion on this motion? Suzanne?
Suzanne, are you gonna ask about the dates?
Yes, I think that we need to do our
I don't
due
connect.
diligence.
Do you want me to mention it?
Yes,
Council, I just want to bring to your attention that this item, because we have 5 this evening, that the majority vote on this issue would be a 4-1 vote at a minimum to pass this. A 3-2 vote would fail, just to share with you. Thank you.
council, you may vote. Okay, thank you, council. This motion has failed because the vote is 3-2. So it does not meet the qualifications to pass as an ordinance.
Council, the ordinance has failed. Would the council like to provide any direction to staff regarding this issue? Is that all right?
Stephanie, you-
I love that this is falling on me. Okay.
That would be very helpful because I highly recommend a lot of the changes in this from our legal perspective. So I would like direction to bring back something else.
Okay.
Oh, go ahead. I was just going to ask the question and maybe help the council if I could.
think I got a
maybe
hold of
we,
this.
we ask the staff to bring this ordinance back to us
Mhm.
and bring with it a fee schedule as Councilmember Zuluaga suggested
Yeah.
earlier. Does
So-
that sound good to the council?
And yeah, just to clarify, I think it would be a good idea to bring it back in the same meeting, but your fine schedule should be like with your fee schedule adopted by resolution. And this, the code, an ordinance amends a code. So we'd have to bring back this ordinance, first reading and then on a second read. And well, first reading, we could bring back the resolution, but it's, it's gotta be just a procedural that
Yeah.
the resolution adopts the fine schedule. It should, and then the ordinance amends the code. Yeah.
Well,
So-
I agree with that. In the ordinance though, can it say that it references a resolution or periodic resolution, whatever it is, and
The
then,
language we use for our fee schedule, like fees and fines to be amended from time to time, that language. So-
and you'll present it at the time you present this, you will also present the resolution. So we'll have it as a package to say, yeah, at this point in time, that's fair. That's a.
Yeah, and it would be good to, I guess, have it like a draft in the first reading so you guys can give input, because then by the second ordinance, second reading, because resolutions only need one reading, so. But again, I could look at other communities, but I don't want to guess what's good for your community, so I guess to do that, the resolution, maybe a draft resolution during the discussion of the first reading, and then by the second reading, so it could all work together.
So what I would ask from council is not for a motion, but consensus giving direction to the city attorney to do this.
Council, is
Shall I?
do we have consensus for the council, for the staff and the attorney to bring the ordinance back referencing a fee schedule and for our consideration, the fee schedule being in a resolution? Yes.
The one thing I would just add is, of course, keeping the removal of the imprisonments that were already struck from the,
You mean
From-
keep it as written?
exactly.
Oh, yes, I highly recommend this, yes.
Yeah,
Thank
I
you.
just, to be clear,
Yeah, no, I
since
know
we're
your thing was
adding the
that-
fee schedule,
Yeah.
but that we want to keep
Yes.
all the removals of the imprisonment where it was
Yeah, I'll
already
keep this
struck.
as drafted. We
Yep.
did a lot of analysis, and if I heard you all corrected, the issue was the amount of the fines, not the other legal advice that we gave. Yeah.
So basically, we just need to bring this, rewrite this ordinance with a different number and then bring a resolution along with it for the fee schedule. That's the
Well,
resolution,
you
is
would
that
also have to add a language
Yeah,
that
add the language for
identifies
the-
the fee
for the fee
schedule.
schedule? But yeah,
Yes.
yeah. Okay, I think we're all on the same page.
And do we have consensus, council?
I believe
Anyone
so.
disagree with that?
Yeah, because my attempt was to separate them into two separate things, but we're going to just combine them and do it in a different.
Well, they will be
mechanism.
two separate things because
Correct.
fees are set by resolution.
That is correct.
The ordinance amends the code.
Right.
As the
So-
attorney.
If I may, I just want to get a nod from the judge. Do you think we're heading in the right direction with this? Thank you.
Thank you, council. Staff, are we clear?
Yes, and it accepts, I think the main point should still have a maximum fine that could, because, the fine schedule can be changed easily. The max schedule, it's people don't do what we did, took the time to go through the code. So, but that could be, right now it's 300. I would recommend at least 1,000. Otherwise it's 2,700. But that's the maximum that's like in the code. But you still going to refer to your fine schedule, which and inflation's going up like 10% a year. So but then that sounds like it would give more that once you see the fine schedule, that gives you more comfort. Yeah.
And is the fine schedule, is it a recommended fine schedule, which still defers to the judge's
They usually
judgment?
are. I've never seen a judge not follow that. And
Well, I'm
usually it's
just-
first, second, third offense.
The language that you would craft, would it be a recommended schedule for fines? Or is it a mandatory schedule for fines?
Usually just says fine schedule and the judge follows that.
Yeah, because if it's
Yeah.
mandatory, then it takes away the judgment of the judge. If it's a recommended, then it provides a guide to the judge on what it should be based on what the council
The
feels are
policy, yeah.
appropriate numbers. But then as the evidence is presented in the courtroom, again, it's extenuating and mitigating circumstances that you have to consider. If it's a recommended or a guide, then they can apply their judgment to up it or down it if it's not a mandatory, this is what it is, or no higher than this, no lower than, just a guide. This is the target we're shooting for as a council.
Yeah, that's usually how it is.
All right, are we clear? Great, thank you.
Consensus, yes.
All right. I'll move on to item 10, new business. Item A is to approve resolution 887, series 2022, Best Western Hotel PUD extension request. And the packet did contain two different versions of this resolution. One would be if the resolution passes, one would be if the resolution does not pass. So you had both of those in your packet for consideration. Presenter tonight is Karen Schmeek. Did I say it right? Thank you. Been practicing.
You ready for
She is.
presentation?
Yes, thank you,
Okay.
Karen.
Sure, I'm going to share my screen, so bear with me. So you have in front of you this evening a request from Bill Page related to the Gold Hill Square South PUD. And this is something that was originally approved in 2016 and has been back in front of Planning Commission and City Council on 2 other occasions for extensions. So with that, I'll go through some of the background in more detail. So the request specifically is to consider a 2-year extension of PUD amendment, which was case PUD 15-001, extending it from February 4th, 2022 to February 4th, 2024. And this is to construct a 70-room hotel at Gold Hills Square South, building number 6. As I was saying, the original approvals happened in 2016. And it was January 6th of 2016 when the Planning Commission approved with conditions an amendment to the 1996 Gold Hill Square South PUD. And that amendment allowed this lodging use, a 70-room Best Western Hotel, and a redesign of Building 6 on 1.37 acres. And then on February 4th of that same year, 2016, the City Council approved the dimensional standards associated with this development. And that included a 31% maximum building site coverage, 98% maximum impervious cover, 46-foot maximum building height, a 50-foot minimum lot frontage, and a 0-foot front, rear, and side minimum building setbacks. It's been in front of these boards on 2 other occasions. It was in February of 2018 when City Council approved a 2-year extension to the year 2020. And then on February 20th of 2020, City Council approved a 2-year extension to 2022. So when we look at the building or the site in question, we have to orient everybody, you have Highway 24 here, this large arc to the left of the screen. And this here in this direction is Highway 67. So the subject property, oh, and then you've got Wendy's in here, and I believe it's down in this area where the city market sits. So the properties we're talking about is actually this lot 3, this lot 2, and then this small lot 8. And so on this particular aerial, you can see lined in yellow here, the proposed building site for the hotel. And then within this particular building, you've got a couple of tenants that are still occupying this space, and that is relevant to our discussion about extensions in general. Because the city ordinance is pretty clear that from the time that you issue a PUD plan approval, that you've got 2 years to begin construction on that, or the plan is voided unless an extension of time is granted by the City Planning Commission. And so, like I said, we've done this on 2 other occasions, and you've got this other request in front of you here this evening. And part of what's been at issue previously within this subject property was the Sherwin-Williams is located there, and they have a longer term lease in that location. And their lease right now will actually run through the summer of 2025. And then we had a new lease that's happened, started in July of 2021, just this past year. And that was Merit Academy has moved into the lower level of this building. And their lease will run through June of 2023. But they have the ability for 2 additional 1-year extensions, which will take them all the way through to June 30th of 2025. So within the subject property, you've got 2 tenants that have leases, excuse me, that are going to be running possibly all the way through the summer of 2025. In your packet, as well as on the slide, you can see the slide of the final development plan that still shows those same property lines, only this time in red, and then how that Best Western Hotel sits within those existing buildings. And then it's over here on this little lot 8 as to where the sign would be located for the Best Western Hotel. Also in your packet were elevations that were part of the original approval. So just to refresh everyone's memory as to what the building would be, is proposed to look like when it finally does begin development. In 2016, some of the findings that were made related to issuing approval of the planned unit development was it was found to be compatible with the surrounding uses and development pattern. It was compatible with the 2010 comprehensive plan, as well as the zoning and other regulations in place at that time. It was found to be logically a logical development pattern with all necessary infrastructure improvements and services. It was in the interest of the public, health, safety, and welfare of the Woodland Park citizens and visitors. And there were no adverse or unmitigated impacts to the site, the natural environment, neighborhood, and it was seen to be a benefit to the community. So when we look at it through today's lens, 6 years later, we look at some of those same criteria. And to date, no new development standards have been adopted by the city since the Best Western PUD amendment for lodging use was approved in 2016 and then extended in 2018 and in 2020. And we're finding that the general circumstances and conditions remain largely unchanged in this area. We do have a couple of exceptions that are noted here. And that is that the city's has updated and adopted a new comprehensive plan. So we are finding this PUD proposal to still be consistent with that new comprehensive plan that was just updated. When we also note that sections of the municipal code, including the excuse me, including the planned unit development district regs, as well as subdivision and zoning regulations, are under review, and that there is the possibility that there may be changes to those which down the line may affect entitlements for this project. Other circumstances that have changed in the area was that the 65-room microtel was constructed and began its operations in 2020. And then the large one was that Merit Academy began occupying part of this property. The Planning Commission reviewed this back at the beginning of January. And at the conclusion of all that, staff was taking the position that since there were no regulations to assess, that we do not have a position or a specific recommendation. The recommendation that came out of the Planning Commission, and we're asking City Council that should you concur, Planning Commission's recommendation is that that a 2-year extension is warranted, and that the approving resolution should include language that states the development is still subject to all conditions and dimensional standards specified within the original approval of PUD 15-001 in January of 2016. And as Mayor Pro Tem mentioned the fact that staff was not providing a strong position there, and that you have that opportunity to really make that decision of whether or not you want to issue an extension or not. There were two resolutions in the packet. One would be denying the extension and the other one would be approving the extension. And that resolution approving the extension does include this language that we're asking for, stating that it's subject to all those conditions and dimensional standards specified back in 2016. So that's the end of my presentation.
Thank you, Karen. Council?
Do you want me to start?
You can start. Go ahead.
Okay. I remember this case from 2 years ago. It's one of the things that caused me to really be engaged in running for city council. And I sat in the chair almost where Don DeZellem is sitting right now. And the thing that bothered me about this 2 years ago was a clause in it. I'm going to go over the clause, but I want to set the stage. I had just come out of a board of adjustment where it was drilled into me, you have to prove an error. Show me an error, and then we can consider your appeal. And I worked at great length to come up with 7 different things trying to generate something that the council would view as an error so that they would then consider what we were asking for. The language in here that bothers me is the application for extension of the time shall be made to the Planning Commission and shall be accompanied by such evidence as is necessary to show substantial need. And I remember those words 2 years ago and listening to the reason there was no substantial need ever presented. So my personal preference would be to table this, send it back to the Planning Commission. I don't think they did their job. The packet does not identify a substantial need that would warrant an extension. We don't have enough to deny it. We don't have enough to approve it. I would like to meet the prerequisite of showing of substantial need by the applicant, and then we could consider it. But again, I sat there with these exact thoughts 2 years ago. And now I'm up here because I was very critical of the council for not doing that. But I don't want to disapprove it. I would rather not approve it until I understand the substantial need. I understand the wants and the desires, but the Planning Commission never met that and said the substantial need is such and such, which is what warrants the extension. Those are my comments.
Thank you. Councilmember Zuluaga.
I wonder whether Mr. Page would be willing to step up to the microphone. I can ask you a couple of questions. Good evening. Good evening, sir. I know that you have been
Can you
around.
just state his name for the record?
Oh, I'm sorry, please. Yeah.
My name
Could
is
you please-
William L. Page. I'm the sole member of Gold Hill Square South LLC, the owner of the property.
Well, thank you, sir. I know you've been a member of the community a long time. We are not the first city council that you have stood before. And I'm sure this is not the first, this is not the first project that you have brought before the city planners and the city council. Would that be true?
I've been before city council since 1964, numerous times.
64, okay.
36 plus 22.
You don't have to confess to your age, sir. I wasn't. So Mike, I too remember this from a couple of years ago. And so my comment to you as a seasoned investor, business owner in the community is, I get it. You've got leases on this piece of land that go through, which are going to bring you before this council again in 2 years. And I suspect again in another 2 years after that, Because by the time your tenants move out, you do all your groundwork, I'm guessing you're probably still not be ready to break ground. So I'm expecting this, if I understand this correctly, it's going to come before council another couple of times. Would that be fair?
That is fair. I think I'll be back in 2 years to see you.
Okay, so practically speaking, what's the pros and cons and the cost to you to say, hey, this project isn't ripe right now. We're just going to table it and bring it back in 4 years' time. What's the cost to you? Or is there a cost? Or is this like a placeholder? I'm kind of seeing, if I understand this correctly, you're doing a placeholder with a project that you've already scoped out. You've got an investor or an agent, or what do you call it? Best Western in any case, who are saying, yeah, we want to do this project with you. Is this a placeholder? Is it expensive for you to go through this process again in 4 years? Will you kind of set the stage of what that looks like?
Well, it's let me explain to you what I went through to get the approval in 2016.
Oh, okay.
That took about 2 years through city planning department. And at the same time, I was talking with the people at Best Western and Phoenix, their headquarters. And that was involved in the same 2-year process. I did 2 economic studies on the feasibility of a hotel, and by the most recognized company in United States and other countries. Best Western is, they go beyond the United States. They're a major hotel, and they're at a level of service to their customers a little bit above the 2 hotels that are here now. And so they look at a different market. The guy that was in charge of the United States came here and looked at the site. He thought it was a fantastic site. And he told me about what a good future site and all the activity that's going to come to the Pikes Peak region. He talked about, they have hotels in Colorado Springs. And he talked about Pikes Peak is a big national draw. Talked about the Air Force Academy and all the people that come. And then he talked about the growth potential in the community with some limited gaming being here, and, we all know that there's 2 big hotels being started or considered underway in Cripple Creek. So that increases all the traffic. Paying for those, I did those economic studies 2 times. In 2014, I started that, and then in 2016, I had another one, and we were all signed up, ready to go with getting into the final throes of signing up with Best Western and paying big fees to become a member. And then 2 years before that, I started working with Sherwin-Williams about relocating their store. And I and went through city planning, and we own a 1-acre site south of City Market between that and the parts, auto parts and Family Dollar and so on. And so we had a lot of money invested in, and we got the site approved to relocate Sherwin-Williams. And that took about 18 months. It's all going down the same track at the same time. And and we got the site approved, the building approved, and we got it priced out. And so then to get down to the final contract to relocate to Sherwin-Williams, everything moves to the real estate department in San Francisco, the West Coast Real Estate Department. Sherwin-Williams has 4,300 stores, United States and Canada, and they're almost like a governmental bureaucracy. So they got different agencies that do approve different sections. And so we sent leases to the West Coast office and so on. And then we did that in January of 2000, December, January, February 2000. And we began to feel like we were being stalled by the West Coast office on getting back with us. And so I end up talking with the official in the West Coast office about how come you're not replying to our lease relocation. Well, Mr. Page, we're not interested in relocating our locations right now. We're focused on opening new stores and growing markets. And we don't want to waste any time. We want to get more stores, new stores open and new growing markets. So, and part of that came back in an email location from the head real estate guy on the West Coast. He sent it to me on a Monday morning about 4 o'clock his time. In other words, he was that far pressed that he was working, starting at 4 o'clock in the morning. So anyhow, that just shelved the whole deal. So, and looking back at it, I think they did me a big favor, because if we would have proceeded on, getting the hotel expansion started, we'd been trying to open it about the time COVID hit 2 years ago, or we might have been open 6 months or so. So it really turned out to be a blessing, So here I'm back before city, and that's the reason for all these extensions. It's my going to call it gut feeling, or watching the economy in Woodland Park and the Colorado and the region, and what happened to the hotel industry with COVID and so on, and restaurants and theaters and so on. I think, with the growth that's happening in our Pikes Peak region, I think, and then the draw of all the makes people come here and rent rooms and so on and visit Colorado. I think there's a good possibility, and say in 3 years, that the market may be back strong, and maybe we got a better economy. So that's the reason I'm here. Now I got $50,000 shoved out in expenses just getting all this stuff to this date, to 2016. And then I've got these extensions going on. So it's a, to come back and do it, I'll probably not be here. And, I'm going to be 85 in 6 weeks.
Wow.
So, everything is, all the ducks are lined up, all the entitlements, all the approvals for an investor to come in, and
So if I understand you correctly, for this project, it sounds like you have the contract set up, the agreements with Best Western. It sounds like the part I don't understand is, so did the deal with the paint store Sherwin-Williams, they had agreed to relocate that, or they had an existing contract, or did you renew a contract? What caused that lease where they are to be so long? That somewhere in that process.
That went back to them signing up the lease. I think the first, they became a tenant 15, 20 years ago. And I think they had a 10 or a 15-year lease, and then they went to 10 or a 15-year extension. But they always want to do it in 5-year increments. And so it just goes back to long-term commitments. And, you know, they're a good tenant. Their rent check is always good. You know, so that's something that's to be thankful about, and they got good product, and so it's just one of those economic situations that happens when you got a building or a project you're trying to do, and you got 10 or 15 people you got to line up and get all signed up on contracts, and everybody goes up to load and shoot in the truck all at the same time. And so that's just one of the risks of being a developer.
Well, I thank you, Mr. Page. It helps me get clear that I don't see that there's any, from my perspective, any reason for council to hinder the extension process. It sounds to me like you've got a lot of the pieces lined up. It is contractual, they're long-term. I get it. Long-term leases are part of the deal in commercial contracts.
Right.
And I understand the pieces, so thank you for explaining those. I don't see any, and I recognize what it says in this here about, as Councilmember Neal is saying. Yeah, I put it here, necessary to show substantial need. To me, you've clearly showed me substantial need from the background, the length of time, the longevity it takes to put these pieces together. I am personally fine to approve this extension. My other colleagues have their points of view, but you've really helped clarify this, so thank you.
On the substantial need, I paid about $7,000 2 times, 2014, 2016, with market studies that showed the need. And, you know, I'll probably have to do that again in 2025 if things are looking good. So I would offer those market studies showed a substantial need.
Yeah.
And we all know what's happened to the economy the last 2.5 years or so.
Thank you, Bill. Council, any other questions of the applicant?
Do you want to go or do you want me to go first? Well, I don't have any more questions for Mr. Page unless you do.
Actually, I don't have any, I don't have any questions for you either. I just had some comments.
I do have more questions, but I wanted everybody to have a first shot at their questions.
Do we have other questions for Mr. Page? You
Yeah.
do, please, if you don't mind, so
Yeah,
he can
so we
sit
go
down.
Sit down.
Pardon?
Ask him now so he can go sit down and then we can discuss.
Okay, Mr. Page, what I was looking at is when your current extension expires, and I see it's tomorrow.
It's tomorrow. Yes, I was going to point
So
that out.
what I was saying earlier, to send it back to the planning commission, that is a non-starter, can't happen. Since I don't think they did their job 2 years ago, I didn't think they did their job fully this year. It's the definition of substantial need. I think your market study does show a substantial need for a hotel. I think that's what your market study shows, but I don't think that's what this municipal code pertains to. It's to show a substantial need for the waiver. Since I don't think they asked that question or presented it at least to us, in your own words, give me something that's a substantial need for having a waiver. I know you've got the wants because you've invested money, but give me a need. Why can't we just wait until Sherman-Williams is gone? If there's no municipal code changes, then all the work you've done would simply come straight back to the planning commission. It should literally be a rubber stamp because you've already gone through the process of meeting all the existing. If there were a code change, then you would have to comply with that code change. And the reason why we have a code change is there's a reason for making a change. Give me some words that a different definition of substantial need. I understand your definition and I agree with it, and that's been met. But with a different definition, what is the substantial need for? Why do we have to grant this extension, please.
Well, if it took another 2 years to get it approved like it did the first time through the planning, Woodland Park Planning Office in the commission and so on, and I was dealing with Sally Riley and so on, and so it's just like throwing another set of roadblocks or let's say it's hurdles. You gotta talk through.
Please talk into my hearing aids are up as high as I can, and I still can't hear you.
Just saying, this is a playing field out here between this podium and where you people, city council people sit. It's just like throwing a bunch of other hurdles. Don't want hurdles out, you run around a track, you jump over the hurdles. You got to go jump all through all the hurdles again, and so I'm not sure I've been around, jump through any hurdles. So that would be a substantial reason. And you know, it's a prime location, and you know, and it's a use that's planned out, you know, with the 70 rooms and so on. And it, you know, retail business has been ruined in the last 10 years in the economy by a lot of different situations. So it converts retail space to another use, you know, and so, you know, it's a good revitalization of 29,300 square foot facility building. And, you know, this hotel takes up about 70% of that. And then there's still existing tenants that will remain.
I'd like to ask a question of the city planner. Maybe she can help because she was at the planning commission meeting. Maybe she can help with some information from the meeting that is not captured in the minutes that might help just for your
Thank you.
information.
Yeah,
Karen, can you help
anything
us?
that would help.
And then we'll get to you, Stephanie.
Um,
Anyone else have anything else for Bill Page? I'm sorry. Bill, if we need you, we'll holler.
Thank you.
Thank you, sir.
Thank you, sir.
Have a seat. Karen, can you help us at all?
I don't know that I can, but I will.
I don't know
try.
either, but we try.
In your packet, we did include the draft minutes from the planning commission meeting. You know, they definitely wrestled with the need for the extension, and probably some, I don't think you all have articulated this yet, but maybe a little bit of frustration as to why isn't this project going? You know, and Mr. Page has tried to explain, he's had a couple different things. One is just working through all the different corporations and everybody else's rules. When you've got existing businesses, you're trying to manage and accommodate. And then just the level of excuse me, review and oversight that we at the city of Woodland Park are obligated to do on behalf of the municipality and our community, since these are the rules that we all agreed to, that this is what gets looked at. So the fact that you have a recommendation to go ahead and extend this again, the commission was very cognizant of the fact that they were likely going to be seeing Mr. Page again in 2 years for at least one more extension. You know, that they recognize that was more than likely what's going to happen. So it was not an easy decision they got to, but I perhaps they were reasonably comfortable with our rules and standards hadn't changed to a substantial degree, nor has the market or the demand or the conditions in this area that would truly warrant saying, no, you need to come back with a different proposal for this area. So that may be the best explanation as to why you got the recommendation you did, even without getting to Councilmember Neal's request for what is the substantial need. That's my assessment for y'all.
And I appreciate that, Karen. So what you've done is kind of given us what the planning commission's thoughts are on the substantial needs. As the planning director, what do you think the substantial need is that would justify it? I mean, you've listened to the planning commission's arguments, you've listened to our discussion. What would you say is a planning? Somebody else comes in with a very similar situation. You would be looking at it saying, okay, in your mind, I need to see a substantial need for, making a recommendation to the planning commission. And it's got to be consistent. What is the litmus test you're using across any project that comes before us to show a substantial need as the planning director?
And you're catching me a little bit cold here. I don't know that I've had opportunity to think about that here specifically for Woodland Park. When you were first asking that question, it's the onus is on the applicant or the developer to demonstrate that more than the planning department saying, you have or haven't. We are, as staff members, are the ones who route this to the appropriate decision makers. And if we fell a little short by not pressing back on the applicant to give us better information about that substantial need, I apologize. But that's really, I think, an onus on the applicant in terms of demonstrating compliance with that. And so that's where, I guess I would more consistently make requests on behalf of the decision makers so that you have better information in your packets.
Thank you, Karen.
Okay, thank you. I think Ms. Alfieri let's go to Catherine next, please.
Okay, so I sat in the same meeting you did 2 years ago. And so for me, this is pretty simple to have no problem with for a couple reasons. One, the code hasn't changed. I don't think it's going to change in the next 2 years. And if it does, this covers Bill in case it does. He's going to bring it back in another 2 years. So the risk versus reward for us approving it is really not that high. I mean, he's going to have to come back at least one more time. And if the code changes, then we don't have to grant the extension if we want to make him follow the code. So I'm not comfortable saying no to the extension just because he didn't prove a substantial need. I don't think at this point he really needs to, in my humble opinion, just because it's we know the backstory. It's an ongoing, and why commission was surprised that he came back 2 years later is a little disconcerting. Because I sat in the same meeting and went, okay, so we'll see you in 2 years, Bill. So that's just my comments. I mean, I think the risk to the city is pretty low that the code's going to change in the next 2 years for this development that would require.
I just want to clarify. Logan, I've been working with Logan Simpson for the many months.
Oh, we are redoing.
Yeah.
We are redoing.
Yes.
It. Okay.
Yes,
All
just
right.
wanna-
Oh, I forgot about that.
Because
little
after the
tidbit, but-
comprehensive plan, it's not a total rewrite, it's reorganization, but myself, Sally, and Logan Simpson, and they were gonna have it done by the end of this year, but it's gonna be a few more months, but before presenting it to planning commission. But just want to clarify, just so you're not relying on wrong information, that we are gonna be presenting an amended land use code for you all.
And is it drastically different?
No, it's not, because it's not a comprehensive rewrite, it's a reorganization. And I believe Karen said the PUD requirements would be actually less onerous on the applicants. And there is nothing like glaring that I could think of that would be relevant in this situation, but I just wanted to clarify in case anyone's, listening, the land use code's not gonna change for 2 years. So that's the only reason why.
Okay, that's fine. So I'll still stand by my argument that it's not, I don't think it's going to change significantly in the next 2 years that it would cost us anything. So that's it.
Excuse me.
Perfect.
Your turn.
Yes, go ahead, Karen. Sorry.
Go ahead, Karen. I'm sorry.
I was going to say, if you found it in the best interest to grant the extension And 2 years from now, if we see Mr. Page again, and the regulations have changed to a degree that you're uncomfortable, at that point, you could certainly deny the extension, if you're not finding that the applicants demonstrated substantial need. And at that point, tell them, go back to the drawing board, come back with something, or possibly, and I'd have to check with Nina on this, but possibly direct them to come back with some changes to dimensional standards that you want to amend the PUD again at that point. So there, I believe there is some flexibility and some options 2 years from now. But that's an initial thought on that.
Yeah, if today or in 2 years, you don't grant an extension, he would have to reapply for the PUD application.
All right. No one interrupt her,
No,
please.
you're fine.
Ms. Alfieri.
So I echo Councilmember Nakai's sentiment. Yeah, the approval of the extension of the PUD is not moving the project forward at all. What it is doing is maintaining the placeholder of the project as it's come to at this point. Because of that, and Mr. Page has put in time and effort and money to get it to this point. And I would hate to see this not being approved and in essence ending up throwing additional repetitive red tape at Mr. Page just to bring it back up to the point he's gotten it to. My personal opinion is it is your property to do with as you please, how you please, within whatever time you please, pretty much. In regards to Councilmember Neal's comments on substantial need, the only argument I'd make towards that is I look at the substantial need of if we don't approve this, he's going to have to go back through the process of getting the PUD approved. So while we may not see it as a substantial need, I would ask who, if any, on this council is willing to take on that project and that cost for him. That is the substantial need, is if none of us are willing to do that on his behalf, if we don't approve this, then that in and of itself for me shows a substantial need because he's already done all of that work. There's a lot put into it, a lot of time, a lot of money. Sorry. So again, that alone, I think if none of us are willing to step up to the plate and say, hey, we're not gonna approve this, but we'll go ahead and get you back to that point. That alone is kind of the justification I need to say, who am I to sit there and say, I'm sorry, I'm erasing all that you've already put into this without really any significant change to it, as we've heard from the attorney and the planning director and the planning commission. Planning director and planning commission approved this. Attorney mentioned that any code changes would be less onerous on the property owner than more. So yeah, for me, it's just a no-brainer. And with that, I would say, Mr. Page, I hope we don't see you back here in 2 years for an extension, but I do hope we continue to see you 2 years from now. So thank you.
Council, any other comments? Go ahead.
I do have another comment, and that is, it's pretty clear to me that Mr. Page has served this community for a very long time. And I would suggest that Mr. Page has probably seen those examples of roadblocks that he expressed here shown increasingly through the years that he has been a business owner in this town. And my concern about all of this deliberation on extending it 2 years is pretty clear to me as a business owner and as an investor. He's put a lot of time, energy, and long-term planning into this. This is not just something that you decide you're going to do and you come before your planning department and your city council. This has been well thought out for a long time, and there are market considerations that are beyond our what is the words it's got in here?
Knowledge.
What we call, knowledge is one for sure, and this whole substantial need. And for him to think that he's got to go through the stress of coming before us again in 2 years' time, justifying his need for an extension, anybody who's got an understanding of the sort of complexity to this, it says this is a no-brainer. In 2 years' time, if I am still on council, I guarantee you it's an approval for me. Just straight out, it's an approval because I understand the length and the depth of what it takes to bring this to the community. So for us to put an expectation of here, oh, if we change the codes on you in 2 years' time, then it's going to scuttle your project. I think that's doing our business community a huge disservice, that he's going to be having this sense of, oh man, I got to dread this whole thing again in 2 more years' time. I would like, well, what's that? I understand that, but what I'm trying to say as council, and is my opinion on council, it's in our best interest to encourage the business development to be able to do long-range planning. And the fact that he's got a contractual issue that precludes him getting this project started now, we know that. We know it now. We're going to know it in 2 years' time. And I suggest it might even be another 2 years after that. But that's the plan. That's what it takes to bring these sort of projects together. And so I think it's, I just don't want to set the tone here of, oh, we're going to hang something over your head again in 2 years' time. I just want you to know from my perspective, I think that it's unnecessary for us to labor over this. And so once again, I support this. And I don't know, we need public comment before we bring a motion or?
We'll get there.
Oh, yeah, all right.
Final thoughts, please. We need,
Final question.
thank you.
I've listened to you, Robert, and I've listened to you, Stephanie and Catherine. We do have a responsibility to protect the citizens from future lawsuits. And what I'm trying to wrestle with this substantial long-term citizen, everybody knows them, been around forever. What if a newbie comes in? Are we going to make that newbie prove a substantial need if they had a similar situation? So it's a rhetorical question. Nina, my question is for you. You were the legal counsel that said an error had to be proven. In your legal opinion, have we met show substantial need?
I think that enough has been brought that you can take to confirm that by the code you've seen substantial need. Also, the Planning Commission has found that, and you have a choice to grant or deny that extension. So I don't want to skew too much into the merits. But I think it's within, I could, either decision I see is within your discretion and would not be arbitrary. I think I could see an argument has been made either way.
Fair enough. Thank you.
So I just have one small comment. I promise it's just a handful of words. I see substantial need has been proven in the fact, and this is just my own opinion, in the leases that he has in place that he cannot get around. And so in my eye and in my opinion, that is one of the things that's significant that's holding back. I'm sure there's other things, and I'm not close enough to it like Mr. Page is, but I would agree, and I will be voting to approve the extension. So council, I'll be looking for a motion from you, please.
Good public comment.
But is there anybody want to comment? It can be heard. It's not required, but
Oh.
it can be heard absolutely anytime, always.
Anybody online?
All right.
Nobody online.
Okay, so
Thank
then,
you.
then
Go for it.
I'll make a motion to approve resolution number 887, series 2022, Best Western Hotel PUD extension.
I'll second. Any further discussion, council?
No,
All right.
I've heard the legal advice it was seeking. She's the same person that gave the legal advice on an error. I just heard the legal advice on hers on substantial need.
Thank you. Suzanne?
Council may vote. Some of you have
If I
already.
was in the right place, I would.
I have nothing. Can I give just a,
Would you be willing to give a verbal?
of course, absolutely. I vote yes.
Okay, thank you, Kate. Council motion's passed unanimously.
Thank you, Bill, for your time.
Thank you, Bill.
You're welcome. Council, we're at 9:00, 9:08. We have one item left before reports. Should we move forward or would you like a short break?
Let's take a short break.
And will 5 minutes be enough for you, please? Thank you so much. We'll take 5 minutes. We'll reconvene at 9:13. Okay, council, we're back in session. And we are on item 10B. Approve resolution 886, series 2022. A resolution establishing a single-family residential tap allotment for 2022. Kip.
Thank you. Before you is resolution 886. Every year, tap management plan requires I come to city council to establish this number for the amount of water taps we will sell in that given year. So in 2022, I have a recommendation to set that number at 80. The tap management plan basically says no more than 60 or 10% of the water tap planning number. The current water tap planning number is 999. That increased from last year because I have new census numbers. So the 2020 census numbers I had that came out this year, the people per dwelling unit actually decreased. Therefore, we are serving a lower population than what we anticipated because previous numbers, the 2010 census said 2.47 people per household or per dwelling unit, and that was decreased to the 2.22. Therefore, we're serving a smaller population than we anticipated, creating more taps available. So this number increased last year, 6 taps, because the water tap planning number to last year was in the 500s. So I just want to make that clear with new census numbers. We reevaluate our water planning numbers, and that is before you tonight. I can go into more detail if you would like, but I would recommend approval of resolution 886, establishing the single-family residential water tap allotment to 80. For
Thank you, Kip.
Welcome.
Council? Nothing? All
I
right.
just wanted to
look-
say I appreciated that one section in there where you talked about the census and the changing in the population and the numbers. That's helpful. Thank you.
Thank you.
Anyone in the audience wish to address council or on Zoom? Suzanne?
No, ma'am.
All right, thank you. Council, I'll look for a motion.
I move to approve resolution 886, series 2022. A resolution establishing a single-family residential tap allotment for 2022.
I'll second it.
All right, thank you. Any further discussion? Suzanne?
Council, you may vote. Thank
Commend
you.
you, council. That was,
Motion is carried unanimously, council. Thank you.
thank you. All right, we're on item 11A, mayor's report. Although we don't have a mayor here, I'll sit in and report. Active parenting, first 5 years, is at the Mountain View United Methodist Church over on Rampart, February 7th and 14th from 5 to 7 p.m. The Woodland Park Public Library is the location of the winter book sale, February 11th from 12 to 4 p.m. and February 12th from 10 to 3 p.m., 10 a.m. to 3 p.m. So you have 2 days for that. Valentine's Day with the Wolves at the Colorado Wolf and Wildlife Center, February 13th from 9 to 11 a.m. And lastly, Kiwanis Mardi Gras Bingo, February 16th from 6:30 to 9 p.m. at the Ute Pass Cultural Center. A good time is had by all. That's all I have. Ms. Alfieri,
I have nothing.
thank you. Catherine,
I have nothing.
thank you. Mr. Neal,
I have one liaison to report on. One board meeting, which was with the DDA on February 1st of 2022. 3 items that I'm going to bring up. The board accepted a legal proposal from McCow, Cox and McCaskill LLP. Marcus McCaskill will be the primary attorney for the DDA. I was designated to notify Mr. McCaskill and the firm, which I did. And we've received their engagement agreement, which I believe will be signed tomorrow. And Mr. McCaskill will be present for the March 1st, 2022 DDA meeting for anyone that wants to meet and greet the new attorney for the DDA.
and that's the first Tuesday of the month at
First
7:30
Tuesday at-
a.m. here.
At 7:30 here.
Thank you.
We went back to the mornings meetings, yes. The second thing, Mr. Perry brought forward just a reminder that it's tax and TIF payment time of the year. And it's our treasurer was not present at the meeting, but the expectation is the treasurer will be following up with the city and county to make sure all taxes payments are being made and all TIF agreements schedules are being complied with the disbursement of the TIF money.
For the reimbursement agreements.
Yes.
Thank you.
And the third thing, there was a very brief discussion around food trucks. No motions were made. Some of the members were for food trucks, some were against food trucks. It was decided that before any thoughts about food trucks being entertained, a much more in-depth discussion would take place, requesting input from the public. And that's all I have. I remembered that third item. That's all I have.
Councilmember
Thank you.
Zuluaga.
Mardi Gras on 16th or Valentine's Day?
Hold on. Wait a minute. We have Valentine's Day with the Wolves on February 13th,
Oh,
but we have Mardi Gras bingo February 16th. So
okay, thank you. All right,
I think they kind of hang out together, Valentine's Day and Mardi Gras.
Mardi Gras. Okay,
Thank you.
yeah. So I just have one report from PPACG. PPACG monitors legislation that's coming up that is relevant to transportation, elderly, and other aspects that PPACG deals with. So the one that we've kind of flagged that we're watching, it seems to be so stupid, but the state is proposing to take over the regulation of cyclists in our city who stop or don't stop going through a light or a stop sign. And it, to me, is just one more example of how the state is taking away municipal control. So we're saying no to it. It's not even not your wheelhouse. How can the state be regulating some guy on a bicycle in Woodland Park? So it's just stupidity plus, but it's on the docket for the legislature, and we've just flagged it to say we really think that's inappropriate. So, and there's legislation that comes across weekly that we review to see what effect it has, and if we can slow it down, influence it, change it in some way that it helps our region. So that's all I have to report.
Thank you.
Yeah.
City Attorney.
Yes, I have a few things. Tomorrow is our 1 year anniversary of when we started working with the city. So we're, still excited to work with everyone and except.
Happy birthday to you. Happy birthday to you.
Did you buy us an anniversary gift?
How could I forget? Although Councillor Neal reminded me the first time I worked with Woodland Park was the autumn of 2019, and that's where Councillor Neal fell in love with my legal advice. A joke. And then I was speaking to Suzanne that she told me that past city attorneys have given quarterly litigation reports. So she brought that to my attention. So we'll be doing that, especially since I know some of you had questions about recent litigation, and I will also include a summary of recent bills regarding the law enforcement integrity and how that relates to some current lawsuits out there. And the last thing is I am passing along to Robert the rest of my time for a joke that apparently Jeff passed along to him.
Yes, Jeff apologized. He wanted to keep his contractual agreement with us for humor. So here's his joke. He says, "What do you call a belt made of watches?" A waste of time.
That sounds like Jim.
It's better than the groundhog jokes we had to hear from the boss yesterday.
So I'm sure Michael's going to follow with a dad joke, but
With that, we'll look for the city manager's report. Go ahead, you can do it.
This one starts with, one time on Suzanne's evaluation. So, no, I don't actually have a groundhog joke. I was hoping you all did because I just keep hearing the same ones over.
Very good. All right, on to D1.
So we, in all seriousness, we do have three quick updates for you. We'll try and be brief. Mr. Wiley's got a water update for us. Hopefully it's better. Does this storm help?
Close. I'll do my best. Let me share my screen real quick. Okay.
Rob, would you
We're not
skip
seeing it.
screen up for us, please? Thank you.
Okay.
Okay, just a quick water update. As you all recall, we went into water restrictions last year in April due to low snowpack. And I'm just going to continue. Just a brief discussion. We get our water from three sources. Those are our augmentation water, which comes from, I'm going to say Twin Lakes in the upper left-hand corner, more towards the middle and the right. You see the North Wellfield and our Loy Gulch Reservoir and also surface water. So augmentation water from Twin Lakes, local groundwater, local surface water. And then the Homestake Pipeline is what brings our augmentation water here. And that's probably our most important source because that water makes it legal for us to pump our local water. If we do not have augmentation water, we cannot pump local, we cannot use our local water. Because we are very junior in our water rights holdings, meaning we aren't in priority. So whatever we use, we have to put back. This map is just breaking down into the basins. The white star in the middle, you see where Woodland Park is. We fall right on the divide between the South Platte and the Arkansas Basin. All of our water rights are in the South Platte Basin, so we have to discharge that basin. The green, the Arkansas Basin, and the yellow, the Colorado Basin, is where we get all of our augmentation water. So we actually take it out of the basin and divert it to the South Platte. So snowpack is very critical in all three basins because in the South Platte Basin, where we're at now, is where we pull the water from, our local water. The Arkansas, or the green basin, and the Colorado, the yellow, is where we pull augmentation water or snowpack from those. And I'll go into the current status of those. So unfortunately, I don't have up to date today. The last time these were updated was January of 2024, sorry, January 24th. You can see this is the Arkansas Basin, or the green. The dark blue line is where we currently sit. And right now, the red line that's on there is the 5-year average. I will say the 5-year average gets less and less every year because we have less and less snowpack every year. Our shares are producing less and less in those basins. Therefore, we have less water. However, the dark blue line represents the 2022 water year. And you can see where we are at 92% of average. The light blue, which is just above it and below it in some areas, was last year. So in the Arkansas Basin, we're tracking about the same as last year. Moving to the Colorado River Basin, you can see the dark blue line. We are above the 5-year average. We're at 110%. So it was a snow a couple weeks ago. You saw it come up, and I should point out, this isn't measuring the depth of the snow. This is just measuring the water in the snow. So how much water will be produced from that snow. The light blue line was the 2021 water year. You can see it was much below the 5-year average. We're above, which is good because the majority of our augmentation water actually comes from the Colorado River Basin. Next basin, South Platte, where we get our local water. You can see same impact with that same snowstorm. The dark blue line actually above the red at 109%. Statewide, we're right around average or a little slightly above average if you look at the whole state. So looking at the three basins, local water being in the South Platte, and then the other two are doing okay as well. Stored augmentation water, this graph. So we track how much water we store in Twin Lakes, Lake Henry, and Lake Meredith. The red X's and red line are the 2021 water year. If I were to say 2021 is shaping up to be, or 2022 is shaping up to be just like 2021, I would expect the same curve, if you will. However, it will vary depending on how fast the snow melts and how fast it comes and if it's all collected or not. You can see the red line here, when we finished in December, we were right around, let's see, 460 acre feet. I do not have current numbers at the beginning of February. I usually get current numbers for January. I could tell you right now, I anticipate us to be about 20 acre feet below where we ended in December. So if you move all the way over to the left of the graph in January, our first point on the map would be right around the bottom dotted line, which would be 60% of storage. Okay, so just over 400 acre feet of augmentation water in storage, which is better than where we were last year at this time, but not much. You can see in previous years, we try to store more water and keep that. However, it's better than last year, where we will start the year, so that's a good thing. But moving forward, I will probably be back in front of you to make sure water restrictions continue. The reasoning for that is in 2021, total raw water used was 818 acre feet. In 2020, we actually used less and we weren't in water restrictions. So are people following them? No. But we will continue to try to save water where we can and move forward. But we are doing better in comparison to last year. As far as augmentation water goes, to put it in perspective, in 2021, we used 240 acre feet of augmentation water. So if we didn't get a drop of augmentation water, right now we have about 400, you'd say, oh yeah, we got plenty of water for next year. However, that doesn't take into account evaporation and losses. So I would say, no, we don't, but we're going to continue to save where we can and move forward. To put that into comparison to 2020, we used 328 acre feet of augmentation water. So you're probably saying, well, what'd you guys do different? So we have what's called lag depletion that was implemented in 2012. It's a way to use the state system in regards to the sources you pump. So some sources that we pump, we don't have to augment that same month. Where let's just say, for example, you pump 100 gallons out of a well and it's a mile away from the stream, that 100 gallons actually gets replaced over the next 12 years. So we have to keep that into account. So when we don't have augmentation water, we try to utilize those sources because it's not a direct payback. And when we do have augmentation water, we'll use the sources that don't have a lag because we have the water. However, the only problem is that'll snowball if you keep doing that. If you keep doing that, you'll accrue a bunch of water that's owed back to the creek, even though you used it 10 years ago. So that's the only challenge. So that's why you see we used a lot less water, augmentation water in 2021 compared to 2022 or 2020, I'm sorry. Moving forward, local groundwater, obviously we need that as well. This graph shows the water level of one of our wells that we just use for tracking water levels. This is basically from the surface to the water. So 0 would be the well is full. The farther you go down, the lower the water level. Does that make sense? Mm-hmm. You can see all the way to the right, January of 21, and it actually goes further. It's dropping below historical levels. And you can see that in 2012, when we had that last drought in the Waldo Canyon fire, it dropped below 2. In 2020, it dropped and it jumps up and it comes back down based on local precipitation. It's pretty reflective of what we get locally. Mr. Neal, you look like you had a question. Oh, okay. Moving on to the U.S. Drought Monitor, the same timeline. This is the most up-to-date map I could collect. You can see where Colorado is. It's in the SL area there. We're into a moderate drought, if you will. And then zooming in on Colorado, exactly where Teller County is, you can see it's still a moderate drought, but I would just like to highlight the yellow area because that's where we do get most of our augmentation water. So they're doing okay in the Colorado River Basin. However, we're always 1 year away from our next drought, to be completely honest. We can save and save and save, but if we have a dry year, we need to go into restrictions. And if you have 2 dry years in a row, then it starts to hurt. So currently, I think we're sitting in a very good spot as long as we do our due diligence and save every drop we can. I've never been in a business where you tell people not to use what you're selling. But it's just the way it is. So we try to do things where we improve our system and track water more efficiently, upgrade meters where we can, fill stations, track every little drop. But I think we're in a decent place and we're going to continue to monitor it and bring back information as we see fit. Any questions?
Thank you, Kip.
Thank you.
Kick it over to Aaron across the table on the sales and lodging revenue update. It's been a while. Thank you for your patience. We're finally caught up. Go ahead, Aaron.
I would hope. All right, I have the December 21, which is actually our collections through November revenues for sales and lodging tax received. So for 2021 through November, we've collected $6,836,029. We're up year to date $642,557 over 2020. And we're up my mistake. We're up $577,018 over previous year. And we're up 9.22% year to date. For lodging tax, we're up significantly higher. We have $290,930 collected year to date through November, which is $69,000 over and 31.5% above 2020. Now included in this number, we do have an $80,000 refund that we issued to Walmart in August, which is why when you look at this map, you'll see that we had a big dip in August. So we're up about 10.5% if you take that refund out, because that was from 2019, but it is reflected in these numbers. But you can see if you look at the top dark purple line there, it's I think that's purple. We're up almost every single month except for August, and that's how the trend has continued. December is usually our biggest month of the year, so we haven't got those numbers in yet, but we should soon.
Before you go to the next slide, can you explain why it is we had such a large refund to Walmart?
Walmart did a review of their sales tax that they remitted to us in 2019, and they realized that they had made an error. So
They had overpaid us,
correct.
and you verified it.
Yes.
Okay, thanks.
If we look at our 10-year historical, 2021 is pretty much above every other year that we've had, other than the month of August as well. So we're seeing historical revenues that we have not seen before. And we're hoping that it continues. Our projection for the year was that we would be up about 10%. So we are hovering right about where our projections were, which is good. And then our 3-month rolling average, again, it trends exactly the same as the other two. It's the highest that it's been. Lodging tax is very similar. It's this dotted green line that we have on the top represents our 2021 lodging tax numbers. You can see that most of the months have been up. We had some very large summer months for July, August, and September. And then October and November, we did see drag a little bit below 2020. We'll see if that continues into December. And these are just the actual data numbers. You guys have any specific questions or anything you'd like me to go to detail on?
I have a quick one, Aaron. You have I'm not sure what page it is on it's page 53 of 66. It says, we got month versus prior year, November 2020 to 2021 with a $13,000 deficit.
Yes.
Do you know what caused the deficit?
We do not, but we did see that it continued. It was November and December. Both were down.
Okay, all right, thanks.
Mayor
I
Pro
would
Tem.
venture to guess that in August, that reflects some of the Veterans Rally as well, certainly. It would have been interesting to see August without the refund to Walmart.
Yes.
So just to clarify, I always forget, for those graphs, are those like for August, are those August sales or August collections for the prior month?
They're always a month behind. So the August number is actually what was collected by us in September. So yeah, it was revenues for August that were collected the month later.
And you're reporting the revenues for August in August?
Correct.
Okay, thank you.
So Aaron, do you break out in the lodging tax what is from commercial, microtel, et cetera, versus Airbnb type of short-term rentals?
We don't in this data, but in our system, we are able to see that.
Are you able to bring that to us in your next report so we can see those to kind of analyze just what amount of that increased revenue from lodging tax is coming from short-term rentals?
Sure, we can work on that.
And that would be something that the council probably in general, you'd get a consensus based on what's bubbling in the community. That data is going to probably become very, very important for us to have available to us. So I would hope we would have a consensus to do that. Good point.
All right, and then
Thank you.
So we're just about done on other updates. Thank you, Aaron. We're just about done with recruitment for police chief. We did our final interviews. We have finished checking references. We hope to make an announcement on who that person is in the next couple of days. So it's a few last things to work through, but we'll have that for you soon. And going back to the point just made by you two gentlemen, staff is continuing to work on basically a needs assessment for short-term rentals. Rob actually has been interviewing other stakeholders in the community, and we're rounding out our list right now of folks who wish to be heard and have unique perspectives that we're trying to take into account. And earlier this week, Karen and I met with members of the Planning Commission who have particular interest in the short-term rental topic, and we've shared our game plan. The needs assessment is you all have charged us with, and wanting to pair up the needs we're hearing in the community with potential solutions. And so we as staff are coming alongside the Planning Commission, sharing that information. It's at some point, it's the Planning Commission's desire, and I agree, to maybe do a joint work session with you all, because this is a topic that they're hearing a lot about. I know it's a topic you all are hearing about. But so we continue to prep for that. To bring you that data, the revenue data. Dave Burgess in our planning department has put together many great visuals and crunching a lot of data for you to look at. Where are the short-term rentals? How many are there? What zone types are they? Are they whole houses that are being rented? Or are they just single rooms? Are the owners local or are they out of town? Stuff like that. So we're taking a little bit longer than some folks might like, but in doing so, we're trying to put together the whole big picture to give you as best information to make a decision on how to move forward as possible. So that continues to move forward.
Michael, I'd like to suggest that I like the idea of a work session, but I also think that it should be more than a work session, and it should include public comment, because I know there's a lot of interest from the public on this. And I think rather than it being thinking that we have all the pieces discussing between the planning board and city council, that the community has the opportunity equally to come and express their thoughts, concerns, and et cetera. So if we can I don't know what other council members think, but I really think it's not a matter of us telling them what it is. I think we really need to hear from the community as well what their concerns are before we start even looking at policy. I mean, it needs to be, that's all part of the fact finding, in my opinion.
Well, you can clearly state that the work session is for the public. I mean, every work session is open to the public.
But it's not open for public comment always.
That's not necessarily true. I mean, the chairman you can have that discussion with the chairman that because before there were planning commission meetings I went to years and years ago where work sessions had public comment. It's just a matter of the chairman's decision. So you can always discuss it with the chairman and open it up for public comment.
Absolutely.
Yeah.
Well, I'm suggesting in advance that it be open for public.
I
Sure.
wasn't disagreeing with you. I was just pointing out that we could do it
We
at the same
need,
time and save a meeting.
Sure. Yeah.
Doing it, doing it at the same time as opposed to having.
we need to
And-
have
and
multiple
as-
ways to hear the public.
And as I mentioned, there's been considerable amount of staff time on our part to go around and talk to people from, I don't want to say both sides of the issue, but that have different perspectives, both from the owners and folks that feel STRs might be a burden on the community as well. So we are trying to do some of that preliminary work, but yeah, absolutely hear you on. Yeah, the public has opinions on this topic, absolutely.
And there's more than both sides. It's multiple, it's multifaceted. It's.
There's a reason why a lot of our partner jurisdictions are struggling with this right now and wrestling through it.
Right.
Absolutely. That's all I got.
All right. Was there a third item, Michael?
No, water, money, police chief and short-term rentals. So there's an
Thank
extra
you.
bonus one. You
All
want
right.
more? No, you don't. You don't want more jokes.
We want an
Anything else,
adjournment.
council? Thank you. We are adjourned.